Court is calling 2024 CR 4900 State versus Damian Trevino. Can I have parties announced?
Welcome, folks. Today we dive deep into a courtroom drama that is sure to keep you on the edge of your seat. This is the case of Damian Trevino, charged with violating the terms of his deferred adjudication. The stakes, high. The emotions, intense. Damian was once given a chance to stay out of prison, but has he squandered that opportunity? Stay tuned as we witness the twists, the turns, and the shocking moments of this legal battle. And don't forget to hit that like button and subscribe for more jaw-dropping courtroom cases.
24 for a term of 4 years. Is that you? Is that you?
Yes, Your Honor.
All right, State.
Judge, do you have the court summary up there again?
Yes.
Violation of condition number 28 on or about the 24th day of January 2025 in Brazoria County, Texas. The defendant, Damian Isaiah Trevino, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant was unsuccessfully discharged from the Stringfellow Safe P unit in Rosharon, Texas, in violation of condition number 28.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of number 28, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Warthel, Damian has pleaded guilty, acknowledging that he has failed to comply with probation requirements. The state, meanwhile, isn't showing any mercy, asking the court to revoke his probation and send him to jail for up to 2 years. But wait, his defense argues that his 15 months in custody should be considered a form of punishment already served. Will the judge take this into account? It's an intense legal standoff.
This is his second MTR. He was placed on deferred adjudication by the court on June 10th of 2024. He was ordered to go to Safe P, and during his time there, he did receive multiple offense reports, including testing positive for K2. And so we are requesting that you sentence him.
Testing for positive at Safe P. Inquiry.
Rolf, here's the thing. Damian admits his mistakes, including testing positive for drugs. He acknowledges he made poor decisions, but the defense pushes for leniency, highlighting his efforts to complete treatment programs. But let's be real here. Should the system be lenient on someone who couldn't follow the rules? Or should it send a message that breaking the law comes with consequences?
15 months, I believe. Yes. About a year, Judge, working, as they just mentioned, working that program unsuccessfully. And requests that the court, his original offer included 1 year, Judge. He did not take that offer.
Oh, no. Here's the thing. I'm not allowed to hear about what your previous plea bargain negotiations. Those confidential.
He's done time,
Understood.
completed programs, and yet here he is again, facing harsh judgment.
He chose an option that gave him more time, and we would like the court to consider that 1 year.
Or will the judge choose to impose a harsher sentence for his repeated violations?
Might be considered satisfactory for the situation that we're in today, and if the court would take that into consideration as serving the time that he's already been in custody.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Damian Isaiah Trevino.
All right, what did you successfully complete on probation?
I went to Lifetime Recovery. I was doing AA meetings at Lifetime Recovery.
Why are you doing drugs at Safe P?
Got into the wrong crowd. Got offered it. Thought I wasn't.
People always think they're not going to get in trouble. If you just follow the rules, you'll do good things. Did he successfully complete Lifetime Recovery?
Yes.
Lart, at this pivotal moment, Damian gets a chance to speak for himself, describing how he fell back into bad company and ultimately tested positive for drugs while in a treatment facility. He reflects on his choices. Are they enough for the judge to show compassion, or is the law going to come down hard on him for his repeated missteps?
Anything else?
I think it, yeah.
No, I was going to parenting class.
Did you complete it?
Right.
No. All right, the court is going to find you guilty, revoke. The court will sentence you to 23 months in the state jail facility. Give you credit for any time served, and the court will request a therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand that?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you want deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition.
Alert 2. And there it is, the ruling. The court finds Damian guilty and revokes his community supervision. He'll spend 23 months in state jail. The judge, however, seems to understand his struggles with addiction, offering a bit of leniency with credit for time already served. It's a small victory, but how will Damian handle what's coming next? Only time will tell.
All right, good luck to you. You're welcome.
I'll get you a copy of the.
You didn't sign both of them. You only signed one. If you would like for
Yes,
them,
sir.
they can make you a copy.
Okay.
Just give me a moment.
Yes.
All right. Court is calling. Are there any applications?
Yes, Your Honor, they should be attached with the paperwork.
All right. Court is calling 2025 CR 000092, 2025 CR 000071, 2025 CR 000069. State versus Xavier Chamberlain.
Who is facing
Can I have
serious
parties
felony
announced?
charges.
Rick Pena for the state of
This one's
Texas.
another heavy hit.
Renee Munoz on behalf of Mr.
The
Xavier
defense
Chamberlain.
has already
And are you
waived
Mr.
enhancements,
Chamberlain?
but the judge
Your
will
Honor.
still have
Counsel,
to
have
weigh
you
in on the
received all
severity of the
discovery in each of these
charges.
cause numbers, and did you review it with your client?
Yes, this is both questions, Your Honor.
Deeper into
In
this
each
case.
cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it, and did you sign it?
Sure.
In each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
Sure.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State and the cause number ended in 9-2. Are you proceeding on the indictment as presented?
No, Your Honor, we will waive the habitual offender enhancement.
Objection.
And in cause number ending in 7-1, are you proceeding on the indictment as presented?
No, Your Honor, with that case, we will waive the habitual offender enhancement as well.
No objection.
And in cause number ending in 6-9, are you proceeding on the indictment as presented?
No, Your Honor, with that case as well, we will waive the habitual offender enhancement.
No objection.
And each cause number, did you review the court's admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 9-2, you're charged with violation of bond protective order 2 times or more within a 12-month period. And the cause number ending in 7-1 and 6-9, you're charged with assault family household member with a previous conviction. All of those are third-degree felonies with a range of punishment anywhere from 10 to 10 years and 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow the plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each case, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering into these pleas, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
In each of the cause numbers, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Your Honor.
Mr. Chamberlain, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. The cause numbers will run concurrently. The state will take in consideration 2025 CR 00070, 2025 AL 002118. There's an affirmative finding of family violence, and the cause numbers ending in 71 and 69. And then in each cause number, there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then in the cause number ended in 9-2, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ended in 7-1, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And the cause number ending in 6-9, how do you plead? Guilty, not guilty, or no contest?
Contest, Your Honor.
State any evidence to support the defendant's pleas.
Yes, Your Honor. With regard to all three cases, state will offer into evidence per each case, State's Exhibit 1 with all attachments.
No objection as to each of the exhibits.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, thank you. You may be excused.
Thank you, Your Honor.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, in each case number, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, it's 6 to 8 weeks for a PSI, or if you would like, I could set it sooner and you can present whatever witnesses you wish to present to the court.
I went over those options with my client and talked to him about the potential timeline regarding a PSI. We're respectfully requesting PSI, Judge,
And that wraps up today's court drama. Damian Trevino, despite his attempts to make things right, will face the consequences for his probation violations, serving 23 months in jail. As for Xavier Chamberlain, we'll have to wait and see how his case unfolds. This has been a roller coaster of a trial, but there's more to come. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.